Okay, class, after installation of labor-saving device and redundancy, the next ground to terminate employee under authorized causes is retrenchment to prevent losses. This is the favorite source of our examination because of the complexity of the requirements. So in this case, the employer may terminate the services of employees based on grounds that the employee is suffering losses or the employees will be experiencing imminent future loss. The jurisprudence will tell us, therefore, that there are two kinds of retrenchment based on the ground. The first ground is to prevent losses, which means that the company is already experiencing losses. The second one is the company will be or will soon experience an impending or will soon experience a loss. Not yet experienced, but it is imminently coming. The former cases that reached the Supreme Court belong to the first kind. And for that reason, the Supreme Court laid down the following requirements. It is a management prerogative to retrench employees, especially when it is experiencing losses, because this is a form of survival on the part of the corporation. Instead of closing down or resorting to bankruptcy, the management or the employer is allowed by law to retrench employees. The best analogy that I can think of would be a ship that is embattled by strong waves and typhoon in the middle of an ocean loaded with cargo. In order to save the ship, we have to throw overboard the less valuable cargo. So this is the best analogy I can think of. So let's go to the requirements. Common to the previous ones, you still have to comply the notice, the 30-day notice rule. And then you have to pay separation pay to the employees. This time, the separation pay has a different amount, because in this case, the employer is already suffering losses or will suffer imminent loss or losses. So the amount would be 1 month for every year of service or 1/2 month, whichever is higher. That means for every year of service. So if the computation of 1 month is higher than the 1/2 month for every year of service, then that will prevail. Now let's go to the other elements or requisites in retrenchment that are unique only in retrenchment. So using the first traditional kind of retrenchment where the company is experiencing losses, the Supreme Court has laid down the requirement that the losses must be substantial, must be actual and real. And if it is expected, it must be reasonably imminent and perceived objectively and in good faith by the employer. This applies to the second one. So let's go to this element where the employer is suffering substantial, serious or actual and real loss. So how do we prove that the company is experiencing this kind of loss? The Supreme Court, through jurisprudence, requires the company to submit financial statement. Always remember that the financial statement must be audited by an independent auditor in order to maintain objectivity. It should not be an internal auditor of the company, because this internal auditor could be biased in the sense that he or she is an employee of the company. Now, the question would be, what will be the period or the number of years to be substantiated by independently audited financial statement. So I just would like to emphasize this case of GJT, Rebuilders Machine Shop et al. Versus Ricardo Ambos, January 28, 2015, where the Supreme Court identified previous cases which shows the number of years that were substantiated by financial statement. If you read this case, you can find a common denominator that the number of years required to be supported by financial statement would be 4 years minimum and 5 years maximum in order to justify the pattern of loss on the part of the company. These 4 years is also enunciated by La Consolacion College of Manila et al. Versus Virginia Pascua. In this case, from 2008 to 2012 were covered by financial statement. However, this financial statement as a rule is not absolutely required. Why? Because according to Supreme Court, that when a company is experiencing losses due to a financial crisis, the court can take cognizance of it. Like for example, the Asian financial crisis in 1997, where the court in that very controversial case, when again it reversed its ruling through a letter by Estelito Mendoza. I am referring to the case of Flight Attendants and Stewards Association of the Philippines versus Philippine Airlines, March 13, 2018. So, although this case has been decided finality, but the Supreme Court reversed its decision and declared that there was valid termination. In this case, the Supreme Court laid down this ruling that it can take judicial notice of a financial crisis which hit Philippine Airlines. For that reason, Philippine Airlines retrenched its employees. So, no need to substantiate financial statement. Another instance when financial statement will not be required is on the second type of retrenchment, when the company is going to experience loss or losses which is imminent, real, and threatening on the part of the company. It must be realistic that it is coming. It is not an assumption. So in this case, since there is no loss yet, you cannot substantiate it with financial statement. However, you can use other evidence to prove that indeed this is a coming loss, or there is a coming loss. Okay. So going back to the requirement of financial statement, general rule, if you are going to use retrenchment and the company is experiencing losses already, you really need to substantiate it with financial statement in order to prove that the losses or the losses experienced by the company is not de minimis, meaning it is substantial. In addition, the Supreme Court also enunciated that before you terminate the employees, you must exhaust all other means in order to save the economy other than terminating employees. Because according to Supreme Court, the termination here must be the measure of last resort. So you should exhaust first. Like for example, you minimize unnecessary unnecessary expenses like perks of managerial employees and supervisory employees. You have to minimize the rental, the operational cost. No? These are expressions of exhaustion of all other means. Then after exhausting all other means, if there's still necessity, then this is the time that you will terminate the employees. Again, even if you will terminate the employee, the fair and reasonable criteria should apply. So I would like to emphasize that if you cannot prove by substantial evidence that you have resorted to the exhaustion of all other means, the termination of employees will become illegal. Then in addition to that, assuming that we are going to terminate employees, then we have to resort to the fair and reasonable criteria. So you cannot just terminate again any employee. We have to look at efficiency, we have to look at seniority, we have to look at the fair or less preferred status. So the Supreme Court has been very consistent on these rulings. So if you will be confronted with this kind of hypothetical question in the bar examination, then you must remember those essential requisites before you terminate an employee under retrenchment. In addition to retrenchment, the fourth ground to terminate employees would be closure or cessation of operation, which could be classified into two. The reason could not be due to business reverses, or could be due to serious business reverses or bankruptcy. Regardless of which of the kind of closure you are talking about here, the requirement of notice is still there. We have to send notice to the employee and to the DOLE 30 days prior to effectivity. However, they would vary as to the payment of separation pay. Another common denominator between the two kinds of closure would be good faith on the part of the employer, where the Supreme Court used the word bona fide in character. When it comes to payment of separation pay, only in closure not due to business reverses where the company is required to pay. In closure due to bankruptcy, the company is not required to pay for obvious reason that it is not in the position anymore to pay separation pay. Now let's go to closure not due to business reverses. Okay. What will be your requirement? Meaning, when we terminate employee and the company is not experiencing business reverses, that is allowed. It is a prerogative of management, provided that it is bona fide in character, meaning it is not used to circumvent security of tenure. So another example would be, it should not be a runaway shop, which means that the company is evading union activities. Where in this case, the company will be liable for unfair labor practice. Okay, so if you are going to close down your business not due to bankruptcy, So again, if we resort to closure not due to business reverses, remember the following requirements. No? There must be notice to the dolly, payment of separation pay, which is 1 month or one half month for every year of service, whichever is higher. Although the company could not be experiencing losses at this time, it may not be also be gaining. So in this case, it could be a prudent management prerogative to transfer to another location. But since the company is not gaining, so the law sympathizes with the company as long as it is done in good faith, then the company will be required to pay 1 month pay or 1/2 month pay for every year of service, whichever is higher. Now, when you close a company due to bankruptcy, as what I have emphasized earlier, there's no more need to pay separation pay. However, it's not exempted from notice requirement. Again, since you are losing, the Supreme Court requires that the losses must be substantiated and supported by financial statement covering a reasonable period showing the pattern of loss. Otherwise, the company shall be required to pay separation pay to its employees. So the closure here must be done in good faith in order for you to be exempted from this liability. An example where it is in bad faith is when the closure is due to change of ownership done in bad faith to avoid liability, or it is used to defeat the rights of labor. Then the successor employer is deemed to have absorbed the employees and is held liable for the transgression of his or her predecessor. What about closure of a company as a result of eminent domain? The Supreme Court has laid down the rule that under National Federation of Labor et al. Versus NLRC, March 2, 2000, the Supreme Court has ruled that the company which closed down its business shall not be liable to pay separation pay. Although it is akin to closure not due to business reverses, but according to the Supreme Court, the closure under authorized causes refers to unilateral and voluntary act of the employer. Now, if the cause of the closure is due to the exercise of eminent domain by the government, therefore, it is not voluntary on the part of the employer. So it would be unfair on the part of the employer to be compelled to pay separation pay.